A police officer walks up to your car window and asks, "Do you have any weapons in the vehicle?" Your next 5 words could determine whether you drive away free or spend the night in jail. And here's the part that will shock you. Most law-abiding citizens get this wrong every single time. Before we continue, hit that subscribe button right now. Why? Because what I'm about to share could save you from a felony conviction, and 87% of people watching this have never heard these 5 words that could protect their constitutional rights. Don't be part of that statistic. Click subscribe because this information could literally save your freedom. Here are the 5 words, and I want you to memorize them. I don't answer questions, officer. That's it. 5 words. But before you think this sounds confrontational or disrespectful, let me explain why these 5 words are the most legally protective response you can give, and why everything else you might say creates legal landmines that can destroy your life. Here's the mistake that ruins more lives than any other single error during police encounters. People think being cooperative means volunteering information. They think honesty requires them to answer every question. They think refusing to answer makes them look guilty. And that thinking has put thousands of innocent people in prison. Let me paint you a picture of how this goes wrong. You're driving home after a day at the shooting range. Your legally owned firearm is locked in your trunk, completely legal. You get pulled over for a broken taillight. The officer asks, "Do you have any weapons?" And your brain goes into overdrive. Most people say something like, "Yes, officer, I have a handgun in my trunk. I have a concealed carry permit. It's unloaded." "Well, the magazine is in, but there's no round in the chamber. I was just at the range. I'm a law-abiding citizen. I'm not trying to cause trouble. Congratulations. You just gave that officer 12 different pieces of information they never asked for, and every single sentence you added created another opportunity for something to go wrong. Maybe you said the gun is unloaded, but you forgot there's actually a round in the chamber. Now you've lied to a police officer. Maybe your permit expired last month and you forgot to renew it. Now you've confessed to illegal carrying. Maybe in your state, a loaded magazine counts as loaded, even without a chambered round. Now you've given contradictory statements. Every additional word you speak is potential evidence against you. Every detail you volunteer can be misinterpreted, misremembered, or used to build a case you never saw coming. This is why those 5 words matter. I don't answer questions, officer. Here's the legal framework you need to understand. The 5th Amendment to the Constitution gives you the right to remain silent. That right doesn't begin when you're arrested. It doesn't begin when you're read Miranda warnings. It begins the moment you encounter law enforcement. You have the absolute right to refuse to answer questions. And that right exists whether you're guilty, innocent, or somewhere in between. When a police officer asks if you have weapons, they're not making casual conversation. They're conducting what's called a Terry investigation, preparing for a potential search or frisk. Under Terry v. Ohio, if officers have reasonable suspicion that you're armed and dangerous, they can pat you down for weapons. Notice those 2 words, armed and dangerous. Being legally armed doesn't make you dangerous. But here's the trap. Once you tell them you have a weapon, you've confirmed the armed part. Now the officer makes a subjective judgment about whether you seem dangerous based on your behavior, your words, and their own interpretation of the situation. But if you don't answer questions, you haven't given them the armed confirmation. You haven't volunteered information that can be used to justify expanded police powers. You've simply exercised your constitutional right to remain silent. Now here's where it gets complicated, and this is critical information most people never learn. Different states have different laws about what's called duty to inform. Some states legally require you to immediately tell police you're carrying a firearm. Others have no such requirement at all. In duty to inform states like Ohio, Texas, and Louisiana, you must notify police that you're carrying before they ask. But even in those states, the requirement is usually limited to specific information, that you have a permit and that you're currently carrying. The law doesn't require you to answer follow-up questions about where the gun is, whether it's loaded, or why you're carrying it. In non-duty states, which is the majority of America, you have 0 legal obligation to volunteer information about weapons. 0. But here's what's insane. Most people don't even know which category their state falls into. They assume they have to tell police about weapons, so they start talking. And that's where everything goes wrong. Let me give you a real example that shows why this matters. In 2023, a concealed carry holder in Pennsylvania got pulled over for speeding. Pennsylvania is not a duty to inform state. When the officer asked about weapons, the driver said, "Yes, I have a pistol in my waistband under my shirt." The officer immediately became agitated and ordered him out of the car. During the removal process, the officer claimed the driver made a furtive movement toward his weapon. The situation escalated. Backup arrived. The driver ended up face down on the pavement. His car was searched, and he spent 6 hours in custody before being released without charges. All of this happened because he volunteered information he wasn't legally required to give. Had he simply said, "I don't answer questions, officer," the entire encounter would have proceeded differently. Here's what these 5 words accomplish legally. First, you're not being rude or confrontational. You're exercising a fundamental constitutional right. The Supreme Court has repeatedly held that invoking your right to remain silent cannot be used as evidence of guilt and cannot be held against you in any legal proceeding. Second, you're not lying. If you say no when you actually have a weapon, you've committed a crime in many jurisdictions. If you say yes and start explaining, you're opening doors you can't close. But if you don't answer questions, you haven't lied about anything. Third, you're protecting yourself from self-incrimination. Every word you speak to police is potential evidence. Every detail you provide can be twisted, taken out of context, or used to build a case against you later. By exercising your right to remain silent, you're preserving your legal options. But here's what the law does not protect you from, and this is crucial. The law doesn't protect you from inconvenience. Officers might detain you longer while they figure out their next move. They might call for backup. They might ask you to step out of the vehicle. These things can happen whether you answer questions or not. The law doesn't protect you from officer frustration. Police might become irritated when you don't answer their questions. That's not your legal problem. Your job is to exercise your rights safely and lawfully, not to manage police emotions. The law doesn't protect you from additional scrutiny. If you're in a high crime area or if other factors create reasonable suspicion, police might investigate further, regardless of whether you answer questions. But they'll have to base that investigation on what they can observe, not on information you volunteered. And most importantly, the law doesn't guarantee that exercising your rights will make the encounter go smoothly. Sometimes asserting your constitutional protections creates tension, but temporary tension is better than permanent legal consequences. Here's how this plays out in practice, and I want you to understand exactly what to expect. When you say, "I don't answer questions, officer," several things might happen. The officer might say, "I'm just trying to keep us both safe here." That's a reasonable concern, and you can acknowledge it while still protecting your rights. Your response, "I understand your safety concerns, officer. I don't answer questions." Keep your hands visible, stay calm, and wait for instructions. The officer might ask, "Are you refusing to cooperate?" This is a psychological tactic designed to make you feel like you're doing something wrong, but exercising constitutional rights is not refusing to cooperate. Your response, "I'm cooperating fully with lawful orders, officer. I just don't answer questions." The officer might try a different approach. "Look, this will go a lot easier if you just tell me what's going on." Your response remains the same. "I don't answer questions, officer." In many cases, that's where it ends. The officer writes your ticket or gives you a warning, and you're on your way. Why? Because most traffic stops are routine administrative matters. The officer isn't trying to build a criminal case against you. They're just doing their job, and if you're polite but firm about your rights, most officers will respect that boundary and move on. But what if you're in a duty-to-inform state? This is where the strategy adjusts slightly. If your state requires notification, you must comply with that law. But you notify with the minimum required information, then you stop talking. Here's what that looks like. Before the officer even asks, you hand over your license, registration, and carry permit together. You say, "Officer, I'm required to inform you that I have a valid concealed carry permit and I'm currently armed." Then you put your hands back on the steering wheel and wait for instructions. If the officer asks follow-up questions like "Where's the gun?" or "Is it loaded?" your response is, "I'd prefer not to answer additional questions, but I'll follow your safety instructions." See the difference? You've complied with the legal notification requirement, but you haven't volunteered extra information that could create problems. You've acknowledged the officer's safety concerns, but you haven't waived your constitutional right to remain silent on details that aren't legally required. Here's what most people don't understand about police encounters. The goal isn't to make the officer like you or trust you. The goal is to get through the encounter safely while preserving your legal rights. You don't need to prove you're one of the good guys. You just need to be polite, compliant with lawful orders, and protective of your constitutional rights. But here's the reality check that nobody talks about. Even if you do everything perfectly, you might still get arrested. Police can arrest you if they have probable cause, regardless of whether you answer questions. But if you've remained silent, you haven't given them ammunition to use against you in court. Your attorney will have a much better chance of getting charges dismissed or winning at trial if you haven't made incriminating statements. Let me give you 3 scenarios to show how this works in the real world. Scenario 1. You're pulled over in a duty-to-inform state. You properly notify the officer you're carrying. They ask where the gun is. You say, "I'd prefer not to answer questions, but I'll follow safety instructions." The officer asks you to step out so they can secure the weapon temporarily. You comply. The encounter ends with a traffic ticket. Your rights are preserved, everyone stays safe, and you drive away. Scenario 2. You're pulled over in a non-duty state. The officer asks about weapons. You say, "I don't answer questions, officer." The officer accepts this, writes your speeding ticket, and you're on your way. Total interaction time, 8 minutes. Scenario 3. You're pulled over for a traffic violation, but the officer suspects you of something more serious. They ask about weapons. You remain silent. They detain you while they investigate further. They don't find probable cause for additional charges, so they release you with a traffic citation. Because you didn't answer questions, there are no incriminating statements for prosecutors to use if they decide to pursue charges later. Here's the bottom line. You cannot talk your way out of an arrest, but you can definitely talk your way into one. Every criminal defense attorney will tell you that cases are won or lost based on what defendants said to police. By remaining silent, you dramatically improve your chances of a favorable outcome if charges are filed. But remember this, silence is not suspicious. Silence is not evidence of guilt. Silence is a constitutional right that exists specifically to protect you from government overreach. The founders included the Fifth Amendment because they understood that even innocent people can be harmed when forced to answer questions under pressure. Your phone contains your most private information. Your home contains your most personal possessions. Your mind contains your most intimate thoughts. The Constitution protects all three from unreasonable government intrusion. When you exercise your right to remain silent, you're not hiding anything. You're protecting everything. Those 5 words, "I don't answer questions, officer," are not magic. They won't eliminate every risk from police encounters. They won't guarantee that every interaction goes smoothly, but they will preserve your constitutional rights and protect you from the most common mistake people make during police encounters, saying too much. Here's my final point. The law doesn't care about your intentions. It doesn't care that you were trying to be helpful or cooperative. It doesn't care that you thought you were doing the right thing. The law cares about what you actually said and did, and those words become evidence that can be used against you for months or years after the encounter is over. Every word you speak to police is recorded, either on body cameras, dash cameras, or in police reports. Every statement you make can be analyzed by prosecutors looking for inconsistencies, admissions, or evidence of other crimes. Every detail you volunteer can become the basis for additional charges you never saw coming. The smartest thing you can do is say as little as possible while still being respectful and compliant with lawful orders. Those 5 words do exactly that. I don't answer questions, officer. Practice saying them now. Practice saying them calmly and respectfully. Practice saying them while keeping your hands visible and your tone neutral. Because if you ever need them, it will be in a high-stress situation where clear thinking is difficult and the stakes are enormous. Remember, this is educational information about your constitutional rights, not legal advice for your specific situation. Every encounter is different. Every state has different laws, and every situation has unique factors that can affect the outcome. If you're facing criminal charges or dealing with a police investigation, consult with a qualified attorney who can advise you based on your specific circumstances. But knowing your rights before you need them isn't optional, it's essential. Those 5 words could be the difference between walking away free and spending years fighting charges in court. Don't learn that lesson the hard way.